Hello, I'm Orion Potres, the director of the Schumpeter project on competition policy at ITIF. The current Federal Trade Commission wants to develop ex-ante rules for antitrust. This means that antitrust enforcement may not only take place ex post through the evolutionary process of courts, but increasingly through ex-ante rules of regulation. In its regulatory priorities for 2022, the FTC declared that, quote, it will consider developing both unfair method of competition rulemakings, as well as rulemakings to define with specific unfair and deceptive acts or practices. So rulemaking for consumer protection is a widely accepted power for the FTC. But rulemaking in antitrust matter is very new, and most importantly, it's quite a controversial area, given the risks of unintended consequences. To discuss the legal and economic implications arising out of the FTC's desire to engage this year in rulemaking for competition purposes, I'm delighted to have a distinguished panel of experts with me. So first, we have Maureen Olozine, who is the former chair of the FTC. Maureen served as a FTC commissioner for 6 years and is now chair of the antitrust and competition law practice at Baker Botts. We're also very proud to have Maureen as a member of the advisory board of the Schumpeter project at ITIF. Timothy Morris, who had served many important roles at the FTC. He has been former chair of the FTC, and today Tim is the foundation professor of law at George Mason University and senior counsel at Sidley. And finally, we have Bruce Hoffman, who is a former director of the Bureau of Competition at the FTC, after serving the FTC also in the 2000s. Bruce is now partner at Cleary Gottlieb. So with such an experienced panel of experts, we will discuss the legal and economic implication of the current FTC's rulemaking ambitions. Those ambitions reveal a precautionary logic towards innovation and disruption. The Schumpeter project of ITIF just released a report titled American Precautionary Antitrust, Unrestrained FTC Rulemaking Authority, and is available on ITIF's website, where we raise in this report a number of concerns with respect to the legal basis, but also the economic cost of the FTC rulemaking authority when it comes to antitrust matters. So Maureen, in a 2015 statement from the FTC, which tried to limit the reach of Section 5 of the FTC Act regarding rulemaking of unfair method of competition, you expressed the view that this statement did not, among other things, require a substantial harm requirement for the FTC to make claims under Section 5. And yet, the current FTC has rescinded this statement, therefore removing any constraint and restraints for the FTC to use Section 5. So the FTC therefore drifts further away from your position that you expressed in 2015. And you recently wrote an article with James Reels where you say that broad unfair method of competition rulemaking would be an aggressive step in the wrong direction. Can you please explain why the FTC's current plans are an aggressive step in the wrong direction?
Great. Well, thanks, Aurélien. Thanks to ITIF for having me. I'm delighted to be on this panel with Tim and with Bruce, and really I look forward to the discussion. The FTC has generally interpreted its unfair methods of competition authority as mapping on to the Sherman Act, so essentially coterminous with that. And that was one of the benefits that the FTC had from its case-by-case enforcement of unfair methods of competition, which was actually rather successful and produced a number of victories in the Supreme Court for antitrust that other antitrust enforcers could use. So that's one of my concerns about moving towards a broader interpretation of unfair methods of competition that exceeds the bounds of what the courts have determined for the Sherman Act. I think the other challenge there is we have seen in the development of antitrust law a movement towards economic understanding, better understanding of the impacts on consumers and competition of a host of behaviors. And as that has gotten better understood, we've seen that taken up into the case law, taken up into agency guidance, things like that. But instead, this push towards rulemaking will move away from that. We'll essentially go more towards a per se kind of approach to violations, which is something we've actually seen, sort of greatly limited to things where we have confidence that the behaviors, the prohibited behaviors, are anti-competitive and hurt consumers. One of the other issues is so that's the issue of really should the FTC do this? I'm a big fan of their case-by-case enforcement. It creates antitrust is a quintessential common law kind of approach that allows this evolutionary understanding of business behavior. The other issue is whether they besides whether they should do it, is whether they can do it. And there's two hurdles there. One is the fact that it's unclear, and I think rather at this point in time, very unlikely that a court will find that the FTC has unfair methods of competition rulemaking in its statute from Congress. The agency is relying on an old case from the DC Circuit that was a combined antitrust and consumer protection rule. And Congress's reaction to that decision called Petroleum Refiners was that to enact the Magnuson-Moss Act, which clearly gave the FTC unfair and deceptive acts or practices rulemaking, but with a host of guardrails, extra guardrails in place to make sure that this is something that is going to, be a wise use of some delegated authority to the agency. By contrast, the current leadership is arguing that these guardrails don't apply, that this statute actually silently gave the FTC unfair methods of competition authority. And because Congress didn't put any guardrails in and was essentially silent about the authority for the FTC on unfair methods of competition, that they can just do notice and comment rulemaking. Current statutory interpretation suggests this is highly unlikely when we see cases like the AMG case and also the recent cases, the case before the Supreme Court involving the vaccines. And so this question of whether they have some implicit unfair methods of competition rulemaking authority, I think is going to run into a real stonewall in court. And then finally, the question is, does this raise constitutional concerns? Because we've also seen the court pay a lot more attention to non-delegation and major questions doctrine. And we've had interesting discussions in other cases among the justices involving, in the Gundy case, involving can Congress essentially delegate this wide-ranging power with few, very little guidance to a federal agency like that. So I think I'll stop there, but I think there's the, should they? No. Could they? Probably not, for two different reasons: statutory deficiency and constitutional separation of powers issues.
That's a very great start, precisely to see that the constitutional and legal limitation of this rulemaking power. I take from your comment that this rulemaking resemble those per se rules of illegality as well, without saying, right? Because we will prohibit some conduct without clearly knowing their competitive effect. So sometimes the competitive effect of this conduct may be very ambivalent, right? And so that would be a dramatic shift, economically speaking.
But I think they see that as a feature of rulemaking rather than a bug, because their argument is it's too hard, it's too high a hill to climb for the agencies to win these cases under the current case law. So they want to move away from, having that kind of evidence. So they really do see that as a feature.
Yeah, just move away from the courts to the regulatory bodies. That's totally right. I may move to Tim. Tim, you offered a book in 1981 where you described in this book the activities of the FTC in the 70s. In the book, you very interestingly refer to a case of Gratz from the Supreme Court that the Supreme Court judged in 1920, where the Supreme Court said, quote, "The words unfair method of competition is not defined by statute, and the exact meaning is in dispute. It is for the court, not the commission, ultimately to determine what they include as a matter of law," end quote. So given your wide experience of the FTC, what can the current FTC learn from the errors and mistakes made in the 70s and perhaps most importantly in the 80s? Do you anticipate a backlash from Congress following what Maureen has just alluded to? Or and should the court think that the FTC may engaged unreasonably in rulemaking? What is your take on that?
Well, thank you for inviting me, and it's certainly a pleasure to be here with two people I've known for a long time, Maureen and Bruce. We've worked together in the past, and they're both good friends. I first started in this area and working with the FTC almost 50 years ago. And I think the way to think about this in your historical questions, Mark Twain is said to have said, it's not clear he did, but it's a great quote. He said, "History doesn't repeat itself, but it rhymes." This is the way to think about it. The political wind, we've got activists with the political wind at their back, and they're concerned over the putative power of business and the harm they're sure that business causes. They take control of the Federal Trade Commission. They prepare an assault on this concentrated power, and they propose to use rulemaking to transform the economy. Is that today? That sounds like it. It's certainly the 1970s. Now, that effort came to ruin and the near destruction of the FTC. What we do know we don't know the extent to which history's rhyming is going to follow the 70s, but we do know that these people today's activists are every bit as determined as were their predecessors in the 1970s. A place to start, and one of my messages is going to be, there is an overlap in both between competition and consumer protection at the FTC. I'm the only person ever to head both enforcement bureaus. And with Maureen, we have somebody who has enormous experience in both. And we'll see there's an interesting interplay between the two. But the place to start is 1964. The FTC did one of the three most prominent rules in its history, and it involved the dangers of cigarettes. A 25-year-old Dick Posner supposedly wrote, and I believe this is true, he was the principal author of the Statement of Basis and Purpose. He worked for a very important FTC commissioner, Phil Ellman. That statement had a three-part test for unfairness. They were talking about unfair deceptive acts or practices, but you'll see we'll come back to unfair methods in a minute. And that three-part test has an interesting history. In terms of what Maureen had mentioned, octane posting, there were a whole series of rules. The FTC had said, we can't do rules. In 1962, it published rules. They said, we change our mind. We can do rules. Cigarettes was this big deal. Congress passed a law preventing the FTC's rule from going into effect, but essentially it was a statute that required the labels on cigarettes that we have a version of today. A lot of these early rules, just like Maureen said, were pled as both competition and consumer protection. But the competition theory was the theory that existed from those early cases that you mentioned, which was called the diversion of trade theory. And that means that if you're engaged in deception, for example, dishonest traders are diverting trade from honest traders. And that was a theory by which the commission would bring consumer protection cases before 1938, when Congress added unfair deceptive acts or practices. The octane posting was a disclosure rule. Care labeling was another example. There was something called the unavailability of advertised specials. There were a whole bunch, or several, and the diversion of trade was the theory. But that leads us back to Posner. The commission had not used this three-part test. Was an aggressive way. One of the parts was essentially a benefit cost test. Another part was, let's look at public policy to divine unfairness. A third part was, let's look at morals and things like that. The Supreme Court, in what turned out to be one of the worst days for the Federal Trade Commission in its history, although at the time it was regarded as one of the best, was March 1st, 1972, when the Supreme Court decided the S&H opinion. S&H was a competition case. S&H involved something called green stamps, which existed as a way to get around the Robinson-Patman Act when they were a form of couponing. The commission didn't like what they were doing. It lost the case in the Circuit Court of Appeals. It went at the front of the Supreme Court. It raised the Posner, the cigarette rule theory of unfairness. The Supreme Court blessed it. And in a footnote, which was dicta because the case had not been brought under this theory, it blessed in dicta the cigarette rule unfairness test. Now that's very important, because if they're going to bring UMC rules, they're almost certainly going to bring them under some expansive view of unfairness. And that's a very expansive view. And even though it was in a competition case, they used this consumer protection definition of unfairness. That led the commission into what I said almost led to, well, did lead to ruin and almost the destruction of the agency, a rulemaking binge in the 1970s. All of those rules were done as consumer protection rules, but many of them, some of them, were actually competition rules. Although the Bureau of Competition, I was there at the time, the Bureau of Competition said real lawyers, they were mostly men, but real lawyers don't do rules. So they left it to the Bureau of Consumer Protection. There was one of the rules that actually passed and was promulgated and approved by the courts involved when you go to your optometrist or ophthalmologist and that doctor prescribes glasses, they have to give you a copy of the prescription. Right. That's a pure competition-based theory. The idea is that approves competition. You can take it, there are lots of doctors that are in the materials business or are tied with people in the materials business. They have to give it to you. The rule began as a rule to preempt. The big part of the rule was to preempt state laws that prohibited advertising. Again, that was a restraint on advertising was a competition-based idea. After the rule was proposed, and there was a similar rule about drug advertising, the Supreme Court, under the First Amendment, struck down state bans on advertising. So that part of the rule wasn't needed. There was another rule involving standards and certification, big area in antitrust law. The commission wanted to have a rule that set out procedures for standards. Really dumb idea, I thought, and I helped kill it when I became director of the Bureau of Consumer Protection in the early 80s. But the point is, as you said, consumer protection rules are accepted. A statute was passed and promulgated on January 4th, 1975. There were rules, and some of what's proposed, for example, it looks like we may have a proposal to do a covenant not to compete rule. Back when I was in law school, you learned covenants not to compete, like in contract law. Mm-hmm. It clearly is partly an antitrust, I suppose, but it's another area. It's not obvious that there's not a role here in Section 18. So let me stop there just by saying there's a history in the 70s in this tremendous rulemaking binge, there was a 15-month period where the commission issued a rule a month to transform major parts of the economy. And some of those rules did involve what we would call competition. And it wouldn't surprise me if, besides unfair methods of competition rules, we also see some rules under the guise of consumer protection that also have competition ramifications. So let me stop there.
That's a fascinating historical perspective, and I think that's very interesting to see that consumer protection and unfair method of competition may lead to this kind of hybrid rulemaking because of the lack of statutory basis for unfair method of competition rulemaking. We may lead to some hybrid sort of rulemaking, and also it's very interesting to see that what is consumer protection and what is unfair competition. Misrepresentation and deceptive conduct most of the time are cataloged at consumer protection, but with some ways and some loopholes, perhaps they can precisely regulate the way companies compete with one another. And I think that's how the rulemakings may take place in the next few months. So I mean, move to Bruce and come back to you, Tim, later on.
Sure.
Bruce, the FTC as one of the rulemaking areas that the FTC wants to be involved in is the notion of algorithmic decision making, the idea that some firms may, through the algorithm, deceive or discriminate unfairly. And the FTC may be, has identified algorithmic decision making as a potential source of unlawful discrimination and as a potential source for future rulemaking. The FTC stated in these regulatory priorities for 2022, quote, "It is not only consumers that are threatened by surveillance-based business models, but also competition," end quote. So what do you think about regulating competition when it comes to algorithm through rulemaking? Isn't a risk of false positive when it comes to very technical and very complex issues of competition through algorithm? What is your take on this notion, Bruce?
Hi, Aurélien. Well, first of all, thank you very much for the opportunity to join this panel and for the chance to do this again with Tim and Maureen, who it's really been an honor to work with over the years. Look, I think it's a great question. I think the question gets to a really important part about rulemaking, or a really important issue about rulemaking that both Tim and Maureen touched on, but which I'll spend all my time on. Let's just leave aside the question of, can the FTC make competition rules? Does it have that power? And leave aside the question of, should it make competition rules? And I think focus in instead on how would it make those rules, not the process, not the procedure, but how do you actually write such a rule? So you talked about competition rules governing algorithmic decision making, right? And I think the primary focus of this that I've seen is the idea that digital platforms, for example, using algorithms of some form or another to provide results, right, or rankings or scores or et cetera, maybe favoring themselves, or what's called self-preferencing in some way, shape, or form, and something ought to be done about that. That's sort of the basic idea. Well, look, I've separately written that I actually think it's incorrect that self-preferencing is ipso facto bad and should be subjected to specific enforcement outside of some contexts in which it can raise antitrust issues, but it's certainly not generally bad. But leaving that issue aside, let's assume you're going to regulate self-preferencing and algorithmic decision-making. Well, how do you actually do it? And this is a really serious issue. The reason I know this is a serious issue is this is something that we've thought about. We thought about it when we were at the FTC in some other contexts when we were considering competition rulemaking. And the area that you run into trouble with is the practicality of writing a rule that actually would be enforceable, not over-inclusive, and cover the conduct you want to prohibit. So, for example, how do you decide what is a platform engaging in algorithmic self-preferencing? If I have a store on the corner and then I get a website and put something up, am I now a platform, even though 90% of my sales or 99% of my sales are going through my physical store? Do I become a platform if I happen to let somebody that's got a similar store in another state use my website? And then if I do that, am I now going to be subjected to rules that say, even though it's my website for my little store that I set up, I somehow can't put my products first? I have to list theirs at the same spot. So there's an enormous definitional problem just with figuring out, okay, how do I know that something is a platform? The second question is, okay, well, how do I, assuming I solve the problem of writing some kind of coherent, defensible, fact-supported, evidence-supported definition of what is a platform that should be subjected to the rule, how do I decide what self-preferencing is, right? So I could possibly write a rule that would say, well, I can't explicitly self-preference my products. Well, does that mean then that I can't put my name, the name of my company on the platform website? Does it mean that I can't have a box that says, here's my featured product for today, and here's other things that your search result might produce? Does it mean that I can't, for example, disclose right up top in bold letters, all results will be my products first and then everybody else's? I guess that would be prohibited, or maybe not. Who knows, right? But explicit self-preferencing, where I either do it directly without using or invoking the algorithm, or where the algorithm weights my product by definition first, is the easy part, but it's also the easy part to evade, right? So if I write the rule and I just prohibit explicit self-preferencing, then pretty much everybody who wants to evade it will likely be able to figure out how to evade it in about 5 minutes flat. And the only ones who will be caught will be the small merchants, for example, who are inadvertently violating the rule. So let's try to make it, okay, I'm going to prohibit less or more subtle self-preferencing somehow or other. Well, what am I going to do? Right? It's going to, if the idea is that somewhere embedded in an algorithm is some kind of feature that's going to preference my products over others, but it's not explicit, that has to mean that something in the weighting factors, something somewhere is designed in some subtle way to weight my products over those of competitors. Okay, well, maybe that could be true, and maybe I could write a rule prohibiting it, but how will I ever find it? Am I going to once a week go and scrub every algorithm used by every platform to see if they've come up with some subtle new way to preference their products over others? And by the way, does anyone think that the institutional capacity exists at the Federal Trade Commission, or for that matter, anywhere else in the government, to actually do this and get it right? The reason that case-by-case adjudication has been favored in competition enforcement is not just the legal issues and even the practical issues that Maureen and Tim identified. It's that it's incredibly difficult to figure out if behavior by businesses in the competition space is beneficial or harmful, and it's very difficult to craft one-size-fits-all rules that covers that behavior. So the issues that I've been identifying show, I think, at least an illustration why that is so, even just in this narrow context of algorithmic self-preferencing.
These are all great points, and I think it revert back to what Maureen said. This rulemaking leads to some sort of per se rules of illegality, and what you just hint to is like basically you cannot prohibit algorithmic decision making or self-preferencing, so you lead to some unreasonable self-preferencing, but then that would conflict with the rulemaking aspect that leads to per se rules of illegality, right? Because if it's all about reasonableness, then, as you just said, the courts are perhaps best suited to identify on a case-by-case basis what is reasonable and what is not reasonable. And also, what I take from what you just said, like that will stretch massively the resources of the agencies in terms of checking what is fair or what is unfair in terms of algorithmic decision making. And finally, perhaps the point that I take from what you say is that this unfair, this rulemaking on algorithmic decision making, on unfair self-preferencing, may very well resemble what we have with the Digital Markets Act in Europe, where there are some rules of unfair that prohibit unfair self-preferencing within the Digital Markets Act, and we'll see how it's enforced, but that's very complicated. So perhaps, Maureen, do you want to revert back to the discussions that we just had about these rules of per se illegality and how this rulemaking will will be possible to enforce these rules of per se illegality?
Yes, no, happy to talk about that. And it reminds me of a saying by H.L. Mencken that for every complex solution, every complex problem, there's a solution that is simple, neat, and wrong. And it does seem that, the capability of the agency to just kind of draw these lines, I think, is really in serious doubt. And the other thing that I do want to mention, and I think Tim's discussion of the FTC's previous forays and the sort of the damage that it caused, is we live in a world of opportunity costs. There are actually good cases to bring out there. And for the FTC to spend so much of its energy trying to promulgate rules in this very challenging environment, and, again, big questions about its knowledge base and resources, and, no knock on the FTC, but it's just a small agency with a big job. The idea, you talked, this panel's about dwindled innovation through regulation, right? I think there is this incredible kind of reflex to say we don't understand it and therefore it's prohibited. So that's one of my big concerns. And it's simple, and they think it's saving them resources, right? It's not so hard to litigate, but ultimately, is that really the best thing for, a dynamic economy?
Yeah.
I don't have any reason to think it is.
Yeah. And also it takes months, perhaps years, to adopt those rules, right? I mean, the history tells that I think the average time for the adoption of the launch of the process and the final adoption of the rules, like perhaps 2 or 3 years. Tim, do you want to? Oh, sorry. Yeah,
no, I was just going to say that's one of the reasons they want to do this as a UMC rulemaking, is because the idea is that they can get it done in 6 months under streamlined APA rulemaking.
Yeah, let me make two comments about that. I agree with that, but there's one real oddity, and then let me talk about what they've done with the other rules. There's one real oddity about their reliance on the Octane case, for example, and also not understanding modern sort of ad law. If you read the 62 rule and Skelly Wright's opinion, even if they have the authority, which, of course, as Maureen points out, is hardly clear, it's not the authority to do a rule the way we think of rules. For one thing, it doesn't get them penalties. But Wright in his opinion says there's this safety valve. If you think there are circumstances by which the rule shouldn't apply to you, you get to challenge that in court. That's not the way modern rulemaking works. The industry gets to challenge it once and say that this rule doesn't make any sense. And once it loses that challenge, then you can't de novo say the rule doesn't work as applied to me. You can do that. It's right there in the opinion and right there in the original regulations. You can do that over and over and over again. And modern rulemaking, including in Section 18 rulemaking, has special provisions in it that says you can't, even if you didn't have the safety valve thing that says you can't do it over and over again. In essence, the FTC gets the rule approved in the Fourth Circuit or the DC Circuit. Someone could take it into they get charged in enforcement of the rule. They could go in the Ninth Circuit or the Fifth Circuit or some other circuit and try to relitigate the whole thing, because there's no protection the way there are in most statutes that allow rulemaking. On the timing question, Howard Beals and I have a paper coming out soon that talks about on July 1st, 2021, the Commission rewrote the rules for rulemaking for these consumer protection rules. Oddly, and this is very odd when you think about it, the only variable that they discussed in doing rules is how fast and efficient the process is. You would think that the substantive quality of the rule would matter. There's not a breath, a sentence, a word, a dot over a period about anything other than speed and efficiency.
Right.
It's like, of course, our rules will be good rules, so we need to get them done as fast as we can get them done. You would have thought they would have at least faked it.
No, they want to move fast and break things, right?
Yes. It was, it was astonishing.
I think it's part of the rationale for rulemaking. When we hear the rationale, is because the judicial process is too long, and they want to do rulemaking because these rules will be more timely, and also they complain about the length and the time that is necessary as part of the judicial process. So speed and swiftness is precisely the core of their argument for rulemaking. But of course, with many, risks of lack of quality of the rulemaking, because of course there's a trade-off between speed and quality. Bruce, do you want to?
Yeah, I'll give you two quotes and then a thought on speed. The first quote is from Tom Smith and his incredible bread machine. And the quote is, "The rule of law in complex times has proved itself deficient. We much prefer the rule of men. It's vastly more efficient." And the second quote is from T.H. White's The Once and Future King, where he was talking about the ant kingdom. And their basic rule was, everything not forbidden is compulsory. So with those two philosophical points, I don't think speed actually works terribly well here. And that's for the reasons that I described in the example I was giving. And it's one of the reasons actually that the antitrust laws were not written as a series of prohibitions, right? It certainly was possible in the late 1800s or again in the 19-teens or the 1920s to have written the antitrust laws as a long list of practices that were prohibited. But the problem with doing that is then you get into two issues. One is infinitely parsing what those practices mean. And the second is the fact that once you've listed everything that's prohibited, everybody can read that and then go find a way to do the thing that's prohibited in a different way, so it's not prohibited anymore, right? And if instead of that, you have rule of reason type adjudication, investigation, litigation, adjudication, then antitrust competition law is able to adapt as the economy changes, and not just the economy itself, but also as knowledge changes, right? So right now, we think we know a lot about economics. Maybe we do, maybe we don't. We know things differently than we did 10 years ago, 20 years ago, 30 years ago. 10, 20, 30 years from now, we'll know things differently. The beauty of a case-by-case adjudicative system of antitrust enforcement is as the economy changes and as that state of knowledge changes, antitrust can change with it. If you write rules, you can't do that. You forswear that opportunity. And in fact, fast as you may think you are, if every time you're trying to write a rule, you're looking at even as short as a 6-month process, then you have a legal challenge after that. So realistically, we're probably talking more like, by the time appeals are done, 18 months, 2 years, 3 years, longer, to get your list of prohibited practices. You're just going to perpetually be irrelevant, right? Except that you will have created two things. One is a complex legal industry of rule construction and evasion. And the second thing is a trap for the unwary, where the people who actually fall afoul of your rules are probably the people you would never be concerned about in the first place, but they lack the sophistication to parse the rules and figure out how to get around them, or even to know that they apply to them. As for example, the merchant I used, I opened a store, I set up a website, and then I discover somebody who sells something like my stuff but isn't near me. Might be it might be somebody I could host on my store. Well, I've suddenly become a platform, and maybe I get subjected to the rule. That's the kind of person you're going to catch. So it's not just that speed, moving fast and break things is a viable option here. I would argue that it's actually not a very viable option, that you would end up with an ineffective, you would move fast and break the wrong stuff, is the way I'd put it.
Right. Yeah. That made me think about these, what you refer as these very detailed rules that are prohibited, sometimes that are not enforceable. That made me think about the Robinson-Patman Act, where most of these rules are virtually not enforceable because they don't reflect the modern economy and the rise of back then of supermarket, but now of the digital economy. So that's the risk of having very specific rules that doesn't reflect the dynamism of the economy. And in that respect, the common law tradition of antitrust may, as you just explained, may be better suited. Maureen, do you want to add something on perhaps on the rulemaking, and more specifically when they refer to non-compete clause, because that's one areas they want to intervene on when it comes to labor market?
Yes, labor and antitrust has become a very hot topic. And that's not to say that there aren't valid concerns there. And when I was at the commission, I supported the guidance involving agreements essentially agreements among employers not to offer certain benefits to workers, right? So I think, it's a worthy area of inquiry. But I think that what they're trying to do here is to say, well, is there something economy-wide that we don't like and that is not traditional antitrust, and we're going to step in to protect labor sort of apart from traditional competition values. And when you see some of the non-compete issues, I mean, there are state laws on these things. And, I guess one of the questions is, why is this a federal concern? But the thing that really worries me, apart from having a law on non-competes, is the idea that now this is getting into merger reviews, right? And now we're seeing questions being asked on whether we, rather than saying, we see something that hurts competition, and it's whether it's competition for labor or it's other forms of competition. But now we're going to say, well, there can be something that benefits consumers overall, but if it leads to a loss of jobs somewhere, that's a reason to block a merger.
Right.
Right. So I think kind of these concepts are flowing throughout in ways that are very, very concerning. And one of the things that always questioned me is, workers are consumers too, right? Are we? We're going to try to benefit, 100 workers at the expense of 1 million others. So anyway, maybe that's slightly off topic, but I just feel like it's sort of this free-ranging, ability to start taking over legislative legislating and topics that are also, really better seated in other agencies, if at all.
No, that's the rise of labor issues in antitrust. We see it not only in rulemaking, but even in the request for information for the new merger guidelines that has just been issued very recently. Tim, do you want to, for the last few seconds and minutes that we have, do you have an advice for the current FTC? What would you say when it comes to rulemaking to the current FTC? And I will ask the same questions to the other panelists as well. If there's something to say in 1 minute about this.
Well, obviously my advice would be don't do it. They're not going to follow that. But I would have some practical advice for them. Look, they're pivoting from cases to rules, and I was involved in the pivot from rules to cases in the Reagan administration. And we wanted to do fraud cases, for example, and I was head of the Bureau of Consumer Protection. I couldn't have done a fraud case if you'd put a gun to my head. So I brought in as a deputy a very experienced litigator, a woman who was a very experienced litigator, and we found people who knew how to do cases, litigators. We found them both in and outside the agency. For whatever reason, and I think I know the reason, but the people who are running the place now do not seem to be going. They could go into almost any Washington law firm and find experienced Democrats who know how to do rules, but they don't seem to want to hire people with that kind of experience, which is quite odd. Mm-hmm. And maybe it's because they think people who work in law firms are somehow tainted. I don't know. It's very strange. Yeah.
So the ability to bring good cases, that's possible, and that's what the FTC should work on. Yeah.
Well, I think so. But if they want to do rules, they ought to go out and hire people who know how to do rules.
Yeah. All right, Bruce, do you want to say an advice to the current FTC? What would be your advice in terms of rulemaking?
So I wouldn't necessarily tell them not to do rules. I mean, there's an interesting constitutional and legal question about whether the FTC can do a rule or not. And the way to answer that is do one and let somebody challenge it. I mean, that would be maybe a worthwhile legal and academic exercise. But I would say start with a rule that you actually can write and can actually define. That, do a rule that is straightforward and relatively simple, as opposed to the kind of things we were talking about. Now, by the way, I don't have a great candidate for that rule. The one that came to mind for me in the past was a prohibition on non-compete clauses in employment agreements for workers making within some range of the minimum wage, right? Something like that would be relatively simple and able to be applied and interpreted and enforced, and not as likely to become instantly out of date. And see if a rule like that can survive. See if you can actually write a rule like that, could actually apply it, and could it actually survive before launching on some tilt at windmills that is likely to end in spectacular failure, not just because the rules get struck down, but because they're not feasible to apply in the first place.
Right. Thank you. Maureen, what would be your advice to the current FTC?
My advice is we live in a world of limited resources and opportunity costs. And if you are spending your time and energy on these things that seem very unlikely to survive in court, you are not bringing meritorious cases, because you just simply do not, have endless amounts of bandwidth and resources and personnel. So I think, it can hurt the agency, but it also means, it always bothered me when people said, oh, you're just bringing easy cases. And you want to say, you mean the cases where the consumer harm is really evident? Perhaps that's where resources should be directed. And the agency's done wonderful things, wonderful enforcement, really moved the case law forward in a host of areas, including in healthcare competition. We are coming out of 2 years of a global health crisis. And I do think perhaps a little more attention on some of the healthcare competition issues, not through rulemaking, might be beneficial, because it seems to have kind of gotten like a little downgraded, I think, on the list.
Right. That's a very good advice, and we can think of hospital mergers, right? This is also a hot topic. Well, thank you so much for these very fascinating discussions. Time flies, obviously, when the discussion is exciting and very interesting. So thank you, all of you, for your very interesting input and insight. I'm sure the viewers and the audience has learned a lot about the FTC Rulemaking Authority. And yeah, let's stay tuned, because it's going to be a very hot topic for this year and the following years. Thank you very much.
Thank you.
Bye.
Thank you.